Hi, this is Professor Pope from Hamline University. This is a video podcast of the class Health Law, Quality, and Liability for Friday, August 31st, 2012. On Wednesday, we started to talk briefly about the formation of the treatment relationship, why that matters, and what we're going to be looking for. And so here we jump into that issue of the formation of the physician-patient relationship, or we'll sometimes refer to that as the treatment relationship. So the existence of a treatment relationship creates the duties that are owed by a physician qua physician. So if there is no treatment relationship, the patient can make no claims for abandonment, for informed consent, or for medical malpractice, because those are claims that are made against someone who owes such a plaintiff duties as a physician. So if the plaintiff and the defendant weren't at the relevant time in a treatment relationship, then none of these types of duties were owed. They're only owed by physicians to their patients. So you have to determine whether or not this plaintiff and this defendant are physician and patient. And the key test, and there's going to be another one, but the key test to whether or not there is or is not a treatment relationship is consent. And we already saw this on the very first day of class with Hurley versus Eddingfield. And so at one level, this is sort of just an extension of Hurley, focusing not so much on whether or not there is a duty to treat or not under common law, but when the treatment relationship is formed. And it's formed when the physician consents to enter into that treatment relationship with the patient. So the most obvious form, or blatant, explicit, visible form of consent would be the contract, the written contract. And sometimes you have this in the healthcare treatment context, but usually not. Sometimes you might not have a written contract, but you have a oral promise. Sometimes you have this. This too would be sufficient. And even in one of our cases, this is probably even what's at issue. But you don't always have either a written contract or even some sort of oral contract. What you do sometimes have instead is just the actual treatment, right? There's just an actual engagement. The physician just starts to take the physician's temperature, starts to examine the patient, starts to do things to the patient at the patient's request. And so it's just implied. It's just the consent, bilateral consent, is inferred from the parties' conduct. And what we'll see is apart from consent, is another core basis for establishing or justifying the existence of a treatment relationship, and therefore the duties that are owed from the physician, is reliance, right? That the physician has induced the patient to rely upon her, the physician, and therefore that creates the duty. And we saw this, remember, back again at the beginning of the class with the Manlove versus Wilmington General Hospital case, where by holding out the big emergency sign, that induced the patients to rely upon that, and that is why, as a matter of public policy, the Delaware Supreme Court said, therefore, there is a duty to treat patients when they arrive with an unmistakable emergency. right? So it's just not fair to put out a sign like, don't wait, our ER is ready for you. And then when somebody shows up at the ER to say, oh, well, we didn't mean you. And so again, this was all today, this is all sort of preempted by statutory obligations, but even under common law, that would be the rationale. It's not fair to sort of invite people or lure them into thinking that there's this ER nearby just in case, and then not accept them. So what we're going to look at is how much interaction between the physician and the patient is sufficient to create the treatment relationship. And just as a summary, I did this chart here, and you could start from the most obvious cases where if the physician actually provides the care, then yes, there's a treatment relationship. If the physician makes a recommendation, you should take this drug or do this, then most probably there's a relationship. If the interaction between the physician and patient is a telephone call, wasn't sort of a live face-to-face interaction, well, then maybe there's a treatment relationship. Just the fact that it happened by phone or even by email or otherwise doesn't necessarily mean that there couldn't be a treatment relationship, and it doesn't necessarily mean that there was one either. We have to know what exactly was said. When there's a formal consult with a second physician, then there's a treatment relationship with both, between the original treating physician and with the consulting physician. But in contrast, where there's an informal consult, we'll come to the Reynolds case with the second physician, then there's not, we'll see a treatment relationship with that second physician. So the first case is Adams versus Via Christi Regional Medical Center. In this case, the patient, unfortunately, just a young woman, died after an ectoptic pregnancy, where the pregnancy sort of takes place in the fallopian tube instead of in the uterus, went undiagnosed, untreated. And so the patient's parents had sued, and in fact had won a sizable verdict at trial. And at least on this point, right, with respect to the claim against the physician argued, well, you can't sue me for medical malpractice because I wasn't in a treatment relationship with you. That obviously failed at the trial court because there's the judgment. And on that particular point, at least the appellate court is affirming that there was enough evidence to find a treatment relationship, as the jury obviously found. So the theory, right, and this isn't core. We'll come back to the substance of the merits of the liability case later in a few weeks. But the theory of professional negligence, or AKA medical malpractice, is that Dr. O, the defendant, should have suspected an ectoptic pregnancy, and therefore he should have advised Nichelle's parents of the danger. And had he done so, they would have gone to the ER hours earlier than they did, and that extra time addressing the situation earlier would have saved her life. This is the theory. None of this, the defendant argues, none of this matters, even if it's all true, because the doctor says, I didn't owe her a duty. I wasn't in a treatment relationship with her. Therefore, I didn't owe her a duty. Therefore, the merits of your malpractice action, of which there are none, he would say, but even if there are any merits to your malpractice action, they're irrelevant because I didn't owe a duty, and that's an essential element of the tort claim. And he has some pretty good evidence right? He hasn't seen, he hasn't talked to, and he hasn't treated this patient for 4 years. He didn't even speak to her on the night in question. He didn't even provide obstetrical care at all to anyone anymore for some period of time now. And he didn't actually do anything, right? He didn't come over to the house to examine her. He didn't do anything. All he did, this is the doctor's argument, all he did was discuss Nichelle's condition in general terms with her mother. He didn't consider Nichelle his patient, and Nichelle didn't consider him her doctor, right, when she filled out the Planned Parenthood questionnaire. So, not bad evidence on the part of the doctor. But Mrs. Adams gets to put in some evidence, Nichelle's mother, with whom the doctor spoke on the phone. Well, first of all, when she called to his service, his answering service, he did call her right back. So it wasn't like he just ignored her. He did call her back. And that is affirmative action. So he's engaging, like he's responding to the inquiry. But that probably by itself isn't sufficient, because just calling her back, again, we need to know what was said, because by calling her back, he could have just been calling back just to say, look, I can't help you on the phone. You got to go to the ER. You know, I don't give advice over the phone. So we need to go step in. What did he do? Well, he listened. Okay, he listened to the mother's recitation of Nichelle's symptoms, and this is the key part, the clincher. He gave his medical opinion, right? He exercised his expert judgment and gave some advice. In fact, 3 separate pieces of advice, right? First of all, Mrs. Adams, the abdominal pain is not abnormal. If she gets worse, take her to the ER and come and see me tomorrow. Okay? 3 recommendations, opinions that the doctor's given to the mother. And these are the words right out of the court opinion. What that advice did was it served to reassure the mother that everything it's not an emergency right now, and therefore dissuade her from taking Nichelle immediately into the ER. So what we're looking at is, says the court, and it's just like contract law, it's an objective theory of contracts. It doesn't really matter what the doctor was thinking in his head. What matters is his external conduct and what the other party with whom he's interacting would reasonably understand. And here, Nichelle's mother, by interacting with the doctor, reasonably understood that the doctor's telling her, you don't need to go to the ER right now, and that's exactly what she did. She followed his advice. And more precisely, she thought, he is agreeing to treat Nichelle because I'm relaying Nichelle's symptoms, and then he is in turn processing those and then telling me what the medically appropriate course of action is to do. It's exactly the role of a doctor. So by A, listening, and then B, responding, he is agreeing, consenting to be Nichelle's doctor. Just a side point here, right? There's another fact in the case that he has been the family physician for Mr. and Mrs. Adams and their 3 children for several years. This probably doesn't play a big role, only because we had this fact in Hurley, and it's not enough, right? So the treatment relationship, again, we talked about this with Hurley, is episodic. So did he agree to treat Nichelle for her current medical condition? No, prior to the telephone call. So the fact is he said other relationships with other members of the family doesn't itself create a treatment relationship between Dr. O and Nichelle for Nichelle's current condition. Next case, Clanton versus Von Ham. Here, the plaintiff is paralyzed after, again, similar to the last case, the argument is that but for the defendant's advice, treatment would have been sought sooner, and that might have avoided the paralysis. Procedural posture here, in contrast to the first case, the defendant gets summary judgment, and that's affirmed, right? So no claim no successful claim by the plaintiff. Well, here, oddly though, because you'd think, why isn't this case turning out like the first case? He previously treated the plaintiff. He called her back. He listened to the symptoms, and then, this is probably the key, most important factor, he recommended treatment, right? Specifically that the medication that she's on, just continue that, right? Which I guess implicit in that is you don't need to do anything new. You don't need to do anything different. The thing you're doing is exactly the right thing. It's despite your new symptoms or new conditions, that is the right thing to do. Looks like the Adams case, so this should be sufficient to create a treatment relationship, which is exactly what the next slide says. This would have been sufficient to form a patient-physician relationship. But the patient perhaps didn't have an attorney who thought this out, because they didn't just take the physician's evidence, but also put in claims and evidence by the patient, perhaps trying to make it seem like a more powerful case by making the doctor's conduct seem more egregious. So the patient testified that she, or at least claimed, this was on summary judgment, maybe this was an affidavit or declaration, said there wasn't nothing he could do for me. So the patient's interpretation of what the physician was doing or said on the telephone was that it was a complete flat denial, right? He won't have anything to do with me, period. He won't help me at all. Well, again, remember, objective theory of contracts. It doesn't matter, there was no meeting of the minds, right? The patient, he may have done things and said words that to a reasonable person would have created a treatment relationship, just as in Adams, but not in this patient's mind. And therefore, she didn't rely. She wasn't dissuaded, and so you don't have the reliance that you had in Adams. And without the reliance, which is sort of the basis for imposing a duty, you don't have the duty. In Lyons versus Greether, the third case for today, we have a patient who is blind, and she has a vaginal infection, and she is denied treatment by the defendant physician because the physician doesn't want her service animal in his office. Put aside the fact that you may have a service animal and ADA issues in this case, and you should think about that, because a lot of the cases we'll be reading will manifest multiple legal problems. And as we move in a few weeks, we'll always be cycling back quickly, at least, to look at not just the one that's the entree on the table, for that particular day, but also, as a way to review, to look at the other legal issues raised in the particular cases that we'll be reading. So here, the plaintiff, since she was denied the treatment that she had with this physician, had to wait a few days to line something up with another physician, and had additional. The condition was aggravated in the meantime, and so she's suing, for that extra pain and suffering. She shouldn't have had to have had the defendant not breached his duty. Here, the defendant filed a demur, and that was granted by the trial court, but now that's being reversed. So note, because this is sort of the claim in the case, that this is not so much medical malpractice, because note, the doctor never saw her, right? He never treated her. That's the whole point of the case, is that it's the refusal itself, all by itself, that is the claim. And so here, the court's not just talking about formation, but they're also talking about termination, which is where we're going to go next. But note that this case sort of spills the beans a little bit on the cases that we're going to go to next on termination. So you might say, maybe I should play the sound clip here, but there's a Paul Simon song, right? There's 50 ways to leave your lover. Well, that might be true. There's only 4 ways to terminate a treatment relationship. And I just wanted to flag that this short opinion does go through those 4 ways. And the nature of the claim here by the plaintiff is that the defendant did not terminate this treatment relationship in one of the legitimate ways. So she had never been seen, right? She wasn't treated by this doctor, but was there a treatment relationship? Because if the claim is a wrongful termination of a treatment relationship, then logically you can't have a claim for wrongful termination unless you can first prove that their treatment relationship existed in the first place. So the court admits, well, okay, she hadn't yet been seen, but she did already entrust her, this is the quote, entrust her treatment to the physician, and the physician did accept the case. Why? Well, and the analysis is pretty simple, but the court basically says, well, we think that there was mutual consent here because she made an appointment for a specific time at a specific place, and this I think they say is key, and for a specific purpose. So these 3 things cumulatively at least are sufficient to create a treatment relationship. It's sort of like in the contract realm where it's offer acceptance, right? The patient says, I make an offer that I would like you to treat me. I will pay you, $50 if you treat me for my vaginal infection on Wednesday at 2:00 at your office. And the appointment was taken. So that's sort of like acceptance, offer, I accept, contract formed. The last case, a little bit different. So it's moving on to a slightly different type of situation. It's Reynolds versus Decatur Memorial. So here the defendant gets summary judgment, and that's affirmed. Okay, so the defendant here says you can't sue me because there's no treatment relationship. Trial court said that's right, no treatment relationship. Appellate court, you're right, no treatment relationship, doctor. And just as a matter of civil procedure, right, note that the court distinguishes that the question about whether or not the circumstances that give rise to a recognized duty have actually obtained is a question of fact, right? So what actually happened, right? That's obviously a jury question, right? Because there's issues of credibility. One witness is testifying that this happened, another witness testifies this happened. That's a jury question. So that's a question of fact as to what actually happened. If we're sure about what actually happened, if it's uncontested, for example, then given what we know happened for any particular circumstances, whether or not there should be a duty in those circumstances, that's a question of law. It's a question of public policy, so that's for the court. So here what we have is little Kevin, who is really, really sick after falling when he was jumping on the sofa. So follow the pink arrows here. So Kevin is taken by his mom to the ER where he's examined. And then the ER, not a defendant, the ER doc then refers to Dr. Sharon Bonds, who's a pediatrician. And Sharon examines him sort of thoroughly. But still, and you can see the CT painting has 4 or 5 separate things that it could be. I mean, it could be anything from spine fracture to bacterial types of issues. So she, not quite sure what it is, right? So she consults the defendant in this case, Fulbright, who's a neurologist. But this consultation, as you saw, and as we'll talk about, is merely an informal consult. So while the ER doc in the upper right and Sharon Bonds in the lower right, they actually examined Kevin, right? They were there. Fulbright was just called, and just given some sketchy facts just to kind of get his ballpark sense of what might be an appropriate thing to do here, right? He never saw Kevin, never looked at Kevin's chart, and so forth. So clearly, the ER doc was in a treatment relationship with Kevin. Clearly, Dr. Bonds was in a treatment relationship with Kevin. What the case presents is the question about whether or not Dr. Fulbright was in a treatment relationship with Kevin. And again, that's the answer is no. Why? Well, the court first clarifies that this was only an informal consult, right? There was zero Fulbright Kevin, or even Fulbright parent of Kevin, interaction. He never looked at any labs of Kevin, never looked at any scans, never looked at the chart, never looked at Kevin. And it's not even clear, it seems rather clear that there wasn't any reliance by the patient. If they didn't even know Fulbright existed. If there's any reliance, it was only by Bonds herself, right? Just she processed what Fulbright says and then determine what she would do. I mean, it was up to her. She could ignore Fulbright. Fulbright said, well, you could try this or this. It would be up to her to pick which of those two things Fulbright suggested she might do, or do neither of them. So everything was processed through Bonds. And then on top of the fact that the level of interaction between this defendant and this patient was didn't reach anything along the lines that we saw in Adams, or that which is our one case with the plaintiff one here. On point. But on top of the fact that there's very minimal interaction between the two, the court also says, well, it would be a bad policy. And again, remember, the question of whether or not there is or is not a duty is a question of law, question of policy, right? The court is thinking, is it a good idea, right? It's up to us to figure out whether or not it's wise to impose a duty here. And we think it's not. Why? Because people are always talking to each other in the hallway. Say, hey, I have a patient. You ever see one of these? Just to get a quick read, from somebody else. See if they have oh, you should read that article in JAMA. If every time you ask somebody, you bounce something off of somebody real quick on an informal consult, sometimes called a curbside consult, it would have a chilling effect on communication and education, because it happens so often, and there's a value in that happening, that if people were afraid to respond to such an informal consult, because they'd be afraid, now I'm going to enter into a treatment relationship with the patient that you're asking me about, and therefore I either have to formally consult me, I don't have to go all the way and do a complete and very thorough job, or I don't want to be involved at all. It's all or nothing. That's not a good way for the healthcare system to proceed, and therefore we don't want to create that sort of incentive. Therefore, no duty for informal consults. Should have mentioned, right, and you see this in the case. I mean, there's other little factors that the court looks to distinguish between, well, what's the difference between an informal consult and a formal consult, right? He didn't charge for this. That's a nice fact, right? So you have some other factors to help distinguish between formal and informal consults.